Hello and welcome to the March to Independence. I'm Steve Friedman, your host. I'm a parent, author, and advocate, and this week we're going to talk about legal protection. These documents are really critical. Many people don't think about them until later in life, but from the earliest of ages, many of these documents are necessary in order to protect your loved one. Let's dive in. There's a handful of legal documents and considerations that you should be aware of. And at the end of the video, we'll talk about how you can get more information on each one of these. The first one I will talk about is last will and testament. So many of you may have a will and testament. If not, you should generally have a will and testament. I would encourage you to do that no matter what. Certainly with a child with or adult with Down syndrome, it's even more critical that any funds that may be willed to your son or daughter with Down syndrome do not violate certain conditions and therefore eliminate their eligibility for certain benefits. So having a will and testament is very important. Having a special needs trust is even more important for those with a loved one with special needs. And that special needs trust will allow you to allocate funds upon your death to your loved one without violating their asset limitations. It's also important that if you have other family members that may be willing proceeds to your son or daughter with Down syndrome upon their death, that they understand how to do that, that they should not be willing it just to that person's name, but to that person's special needs trust. So once you get a special needs trust set up, then you should share that with family and friends that may be considering providing some benefits to your son or daughter. So that's the first thing, and I would encourage you to do that very early on. Second thing I would like to talk about would be guardianship. Usually at the age of 18, in most states, a minor becomes an adult and is able to make responsible decisions on their behalf. So up until 18, you are technically their guardian. You have the responsibility of making those decisions. You have every right to be in the room and help make decisions and overrule any decisions that your son or daughter may wish to make. Those decisions could include health decisions, how to proceed, whether to have a surgery, how to take care of themselves, to financial decisions. So in the financial video we covered in the last session, we talked about a myriad of different complexities that we have to navigate in order to make sure our loved ones get the benefits that they're due and also that they preserve those benefits. If the guardian, in your case, the parent up to the age of 18, has the right and responsibility to be aware of all those things and to manage the financial and legal aspects in the best interest of your son or daughter. However, at 18, if you don't take steps, then you lose guardianship. This is something that just happens at 18 if you don't do anything. And as a result, after the age of 18, if they choose to make certain decisions, they have the right to do that. Those decisions, again, can be health and financial related. It could be I want to move out, I want to get married. There's all sorts of different aspects that they would have the ultimate decision to make. If the other person involved in the decision, let's say the doctor or a teacher, doesn't feel that your son or daughter is in a position to make the right decision or the best decision, a well thought out decision on their behalf, then the authority, the teacher or the doctor in this case, would go talk to the state, and the state would provide somebody to help them make that decision. They would not come talk to you because you have no legal standing if you're not the guardian. Some people believe that it's important not to have guardianship. Let's let our individuals with special needs make those decisions for themselves. I am a big proponent for person-centered planning, that the individual, the person with Down syndrome in this case, has the opportunity and the responsibility to make decisions for themselves. However, I'm also a big advocate of maintaining guardianship through the parent or caregiver or some other responsible adult. That doesn't mean that your son or daughter wouldn't be in the room to help make those decisions, but ultimately you get to make the decision that can impact their lives impact their funds and their health for years to come. So I would encourage you to get guardianship. What you need to do if you're pursuing guardianship is that you need to make sure that before they're 18, that you go to your local court and you file for guardianship. You may need to secure a lawyer in order to do this. It takes some time, it takes some money. Once you secure that guardianship, usually on an annual basis, you have to fill out a short form or report, and you have to pay a fee that's usually less than $20 in order to continue to extend the guardianship and get guardianship papers, which you would need to share with your doctors, teachers, financial planners, and so forth to show that you do have guardianship and can make these decisions. I can't overemphasize the importance of, at the very least, making this conscious decision. Don't let 18 pass by without thinking about and understanding the pros and cons of securing guardianship for your loved one. The next financial and legal instrument that you need to be aware of is the ABLE account. So the ABLE account was set up several years ago, and it helps protect some of the funds that your loved one may earn or be gifted, and it protects them against the asset limitations that we talked about in the financial video. An ABLE account is available in any state in the country, and actually you don't have to live in the state where you secure an ABLE account. So you can just Google ABLE and find ABLE accounts in various different states. They're generally the same, but I would encourage you to certainly read the fine print and understand what you're getting into. But when you set that up and you set it up where funds such as paychecks or gifts go into the ABLE account instead of their checking account, then it doesn't violate the legal limitations for assets. It's very simple, doesn't really cost much of anything, a little bit of an administrative fee every month, but I would encourage you to look at ABLE accounts. The next item, which is not really a legal document, is a letter of intent. So everybody really should have a letter of intent. So it kind of goes along with the will and testament. In the case where you can't take care of your loved one or you pass away, then the letter of intent provides really the non-legal information to whoever's going to be the caregiver for your loved one. Talks about what their favorite things are, it talks about their quirks, about their interests and dreams, it talks about what their normal routine might be. It also provides information about who is on their independence team, who's helping them with financial and legal issues, what their plans are, what your plans are for independence for them as well, around things like continuing education and work and housing, where there are funds, what things that you have applied for. So this is critical information that people need to know. If you don't write it down somewhere, then it's lost if you're not able to take care of your loved one. So a letter of intent, very important. Usually a financial planner that might be assisting you on a variety of different financial aspects for your son or daughter can give you a template for a letter of intent. And then you can fill that out, save that, share that with your independence team and loved ones that might need to know. Finally, I wanted to make sure you're aware of event-based situations that can change the legal status for your son or daughter. There are 4 that I'll list, but before you run into these situations, it's important that you consider what are the legal and financial impacts of these situations. Divorce. So if parents get divorced and one of them has child support due to the person with Down syndrome, that income for the person with Down syndrome can impact their asset maximums. And there are legal instruments you can put in place that will protect that money, and so it doesn't count against your legal maximums, but you need to be aware of that before you have a divorce decree. Gifts. We talked a little bit about this with regard to last will and testament and special needs trust, but even small gifts, holiday gifts, birthday gifts, if they go into their checking account, then they do impact the asset limitations. So you need to be aware of those gifts. If they're working and they get a holiday bonus, that's part of their assets. So you need to be aware of that and share that with their employer as well. Moving's a really a critical thing because we talked a lot about this in the financial video, but if you move from one state to another, in many cases you change the financial options and obligations. There are, as we talked about, some Social Security provisions that are federally managed, but many of them are state managed. And so when you move from one state to another, there are different considerations that you need to be aware of. Additionally, if you are in one state and you're on a waiting list for the waiver program and you leave that state and move to another state for whatever reason, you are taken off of the previous state's list and you have to start over new in the new state's list. It doesn't matter whether you were the next person in line in the first state, you have to start all over. And if you're moving to a state that has a long waiting list, and many of them have 5 to 20 years waiting list, you could have just set yourself back by many, many years. So you need to be aware of that. It doesn't matter whether you're moving for a week or a year, or you're moving because your job has forced you to move. You'll still start over. So definitely keep that in mind when you're considering moving for any reason. And finally, marriage. Marriage by somebody with special needs has impacts. So your son or daughter will have certain benefits that are available to them, as we talked about in the financial video. Regardless of whether your son or daughter marries somebody else with intellectual disabilities or not, once they marry, then their assets are pooled together legally, and oftentimes that means that they may lose eligibility for certain benefits. If they both have Down syndrome or other intellectual disabilities, and they're both getting Social Security and many of the other financial benefits that we talked about in the financial video, once they marry, they do not get the combination of those two. They get less than that, considerably less than that. So many people consider having a union together without a legal marriage document in order to preserve that. It's an unfortunate condition, but it's something, again, that you need to be aware of. There are 3 ways that you can continue to learn more information. One is you can join our website, beyonddownsyndrome.net. There you'll find a lot more information on each of these topics. You'll also find resources available to you. And we also have an independence plan worksheet that you can download and save. You can amend it, modify it, share it. So it gives you a bit of a roadmap of where you're going to, and you can follow that along. It gives references so you can learn more about different topics in the independence plan worksheet. Second item is to continue to join us for the March to Independence video series. There's many other topics. If you have skipped some, especially items like health and financial, which we've talked about today, you can easily go back and catch those on our YouTube channel. And finally, you can check out the book, The Essential Guide for Families with Down Syndrome, Plans and Actions for Independence at Every Stage of Life. The book really it acts as a roadmap for the family and the independence team. Where do we go from here? What are our options? What are the pros and cons of each of those options? What are the resources, and how do we make that happen? So instead of having to feel overwhelmed or that it's just too much of a black box to even understand and therefore pass on these critical decisions, the Essential Guide provides the roadmap for you to get there and the information, so you don't have to go searching for links and documents and information about each of the steps along the way. So I'd encourage you to check that out as well. It's available on our website and on Amazon.com. Thanks again for joining today, and I look forward to seeing you on our next video. Take care.